Is there an next through a speaker or anything?
Cheryl, can you hear me? It's Kathleen. It says my speaker's not working.
Yeah, I can hear you, Kathleen.
You want to hear her? What's at the top?
Coordinator screen.
Is it the green?
Can anybody hear me? It's Kathleen.
It's not.
Yes, we can hear you, Kathleen.
The microphone is working. Doesn't seem.
Yeah, I can hear you, Kathleen. No issues.
Can't hear Ann.
It's not.
This is a problem because
Can-
without me, we don't have a quorum tonight.
Okay, so can you hear me? Kathleen?
What do I do?
Okay.
Please check your connection, or maybe it's just,
There's no connection. Sign in again. Is there anything down the bottom that's saying it's not, somebody's not?
I think we have quorum. It's 6:30 by my time at this point. Just want to make sure we do before we get started. Have I got Mr. Do I have Mr. White? I have Ms. Markovich. Ms. Willis, are you back on? Are you able to
I
hear?
am. I was having trouble. It said my speaker was off, so it went off and came back on, and it seems to be working now. So keep our fingers crossed.
All right, so the only person then that we are still waiting for is Mr. White. But at this point, we do have quorum, so I can start the meeting. So with that, a little more adventure this evening than we've had in the past. So, well, good evening, everyone. Bonne soirée à tous et bienvenue à cette audience en ligne du Comité de dérogation pour la Ville d'Ottawa. Welcome to this online hearing of the Committee of Adjustment for the City of Ottawa. Committee of Adjustment is a quasi-judicial tribunal that's appointed by the members of City Council to make decisions on certain types of applications under the Planning Act. My name is Anne Tremblay, and with me this evening is Ms. Kathleen Willis, Ms. Julia Markovich, and we are expecting Mr. Colin White to join us shortly. From committee staff, none of this is possible without their undying assistance and dedication to the committee. So welcome to Acting Deputy Secretary Treasurer, Ms. Cheryl Williams. We have coordinators this evening, Ms. Emily Monette, Ms. Mandy Nguyen, and also Ms. Maddie Harriman Fernandez. So thank you to everyone for making it all happen and organized this evening. This is video conference, or this is video stream. My apologies, on YouTube. You can always get a copy of this if you want to see it later. It's being archived with the agendas on the city's website under the Committee of Adjustment. So if you have any trouble finding it and you're looking for it, just reach out to committee staff. They can help you with that. So before I begin, a couple of things that or statements that we really need to make so that everyone understands exactly how the committee, or what jurisdiction that the committee has with regards to the applications that are before us. And in fact, the Committee of Adjustments jurisdiction is actually quite narrow. So things that we cannot consider are aspects of the proposal that are not related to the minor variances. So if you have an issue with the rear yard or the height, but that's not in fact a zoning standard that's being varied, then it's not an issue that we can really address as part of the committee. Also, nothing to do with noise, pollution, property maintenance, property values, illegal construction, prosecution for illegal construction to be more precise. And we certainly won't entertain any adverse comments, negative comments about neighbors, agents, or the applicants. So, and lastly, the thing that we cannot do is if in the course of discussion, we determine that in fact, an additional minor variance may be required or greater relief from the zoning bylaw is required. In those cases, we need to adjourn that item to a future, and I won't say the next, because it will all depend on whether or not it needs to be recirculated, but a future meeting of the Committee of Adjustment to be heard. So as part of the statutory requirements under the Planning Act, each applicant is expected to post a sign on the property and then to file with the committee a statutory declaration that they have done that. My understanding is that we do not have any of those this evening, so we will be administering either a solemn oath or an affirmation verbally with the applicants or the owners. So with that, then if we lose quorum, we're 4, so quorum is 3. If we lose more than 3, 3 of us, or I guess more than 2 of us, then we will have to, in this case, have to adjourn the hearing unless we can resolve some of those technical difficulties. We'll have to step down any issues or applications that haven't been heard to the next meeting. So in terms of our process for this evening, what typically happens is we and the committee members have had a chance to review all of the material before we get here, and we do have a chance to pre-meet to make sure that we do understand the files or any of the information that may have come in just the last few days prior to the hearing. So we do have that information knowledge already. But what we try to do then is, in some cases, depending on the complexity of the application, we might ask the applicant or the agent for a presentation, or in some cases where it's fairly straightforward based on the material we've reviewed, that then in those cases we fast track an application. And where we fast track the applications, and in the case of a presentation, the first group that gets a chance to get clarification is the panel members. So I will ask the panel members at that point whether or not there's any additional information that they require. Once that portion is done, we will move on to the public portion. And so we do keep a speakers list. I have a couple of names for a few of the applications, but that doesn't mean that anyone who's tuning in tonight can't have a say. So under the public hearing, once we've heard from the people on the list, I will open it up to the audience, and anyone who wants to speak on a matter, whether it's for or against the proposal, all you need to do is raise your hand, and then one of the coordinators will then bring you in so that you can address the panel. Once all of that is done, and the panel members may ask you some questions regarding your submissions. And if, by the way, you're not on the list, I will ask you to start your presentation with your name, may need to ask you to spell your last name, and also your municipal address. Once all that's done, it's time for the committee to deliberate and to render a decision. We can make a number of different decisions verbally. We can either grant the applications, we can deny the applications, we can adjourn the applications, and rarely we can reserve on a decision, which only means that we have so much additional evidence before us that we need the extra time to really deliberate and think through all of what we've heard, new information, and then we render a decision before we leave essentially the hearing for the evening. So we will terminate the overall hearing, and then what we do is we regroup into a secondary hearing as panel members to deliberate. So once the evening's decisions are rendered, you will get within 10 days of the hearing a written notification about that decision. And what that is essentially a formal record of why the committee has decided on an application in given ways. All of those decisions are appealable to the Ontario Land Tribunal within a 20-day appeal period. And of course, there is a fee for that. So items of business before we get going. Any member have a declaration of interest on any of the items before us this evening or that were before any of the panels earlier today? Anyone? All right, so I'm seeing no declarations of conflict of interest for the record. Confirmation of the minutes, we have one set September 15th. Do I have a mover to adopt those minutes? Ms. Markovich, thank you, seconded by Mr. White. With that, we can go on to the adjournments before we start hearing some of the applications. I've got a couple this evening. So the first one is application 1 and 2. It is for Roca Land Holdings at 7 Winlock Crescent. Mr. Segreto, please, if you could come forward.
Good evening, Madam Chair, committee members, Michael Segreto.
Good evening, Mr. Segreto. So I understand that this request for adjournment is actually a request by you.
It is.
So did you want to just, for the record, simply outline why you're asking for this adjournment?
I just found out recently in the last couple of days that the signs were never properly posted. Therefore, I'm asking to adjourn it to the November 17th hearing, if that is possible, so we can post the signs for the 2 weeks and make sure that they're properly visible on the site.
Thank you, Mr. Segreto. I really appreciate that you did identify that as an issue because, of course, without a statutory declaration or a solemn oath, we can't move forward with hearing the application. And in this case, you're clearly not comfortable doing that. So I thank you very much for bringing that to our attention. With that, then, members of the committee, any questions about adjourning this item to November 17th? All right, seeing no questions, is there anyone in the audience who would like to speak to this request for adjournment of this application to November 17th? Now is your chance. Not seeing anybody come forward, in which case, members of the committee, all those in favor of the adjournment to November 17th? All right, so for the record, the application is adjourned and we'll see you in about a month's time, Mr. Segreto.
Thank you very much. Thank you.
All right, thank you. Okay, the next application is application number 3. It's for 66 Chippewa. Mr. Posen, if you're available, please.
Hello, Madam
Good
Chair.
evening.
Can you hear me?
Yes, we can hear you. We can see you. We can hear you. That's great.
Okay, great. Good news. Good news.
Okay, so Mr.
yes.
Posen, you are aware that the planning department is asking for an adjournment of this application.
Yes, we are aware. We had a meeting about it on Friday and we're in concurrence with the request.
Okay, so in this case, there's a possibility that there's a number of added variances that are required. My understanding is that you've asked for a November 3rd date. That, however, will not give you the timeline that you need in order to get that circulation through. Would you prefer November 17th by any chance?
So to clarify, and completely understood, Madam Chair, but actually to clarify, the revised plans that were prepared even today eliminates most of those variances, and the intention is to remove the rest that were identified just earlier today. These are all very minor elements, Madam Chair, with things like, little projections and walkways and these types of things that are very easily fixed. And in fact, the client and the architect have every intention on fixing them so that there are no more variances beyond the lot shape and size.
Okay, so I believe I'm hearing that your undertaking is you have no interest in adding variances and are willing to revise the plan to the extent that it then does meet all of the requirements. Okay, fair enough. In which case, November 3rd is your preference?
Yes, please.
Okay. Members of the committee, any questions from Mr. Posen? All right, no questions from the committee. Is there anyone in the audience who would like to speak either for or against this request for adjournment? All right, I'm not seeing anybody come forward. Members, all those in favor of the adjournment to November 3rd? All right, for the record, the adjournment is unanimously granted. So Mr. Posen, we'll see you in a couple of weeks.
Sounds great. Thank you, Madam Chair.
All right, thank you. Okay, we're going to go on to our regular items for the evening. So I'm going to start with number 4, which is for 1871 Maryvale Road. I'm looking for Mr. Bond.
Hi there. Can you hear me?
Yes, we can hear you and we can see you. Good evening, Mr.
Okay,
Bond.
great. A bit of a delay
Sorry.
there. Good evening, Madam Chair and members of the committee.
No issues at all. So we're not going to ask for a presentation, but I do believe that I need to read something to you before we get going.
Mhm.
So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days prior to the hearing, and that that sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I do affirm that to be true.
Excellent. In which case, we're not asking for a presentation. I'm going to throw it out to questions by the committee. Anyone? Nope, I'm not seeing any questions by anyone on the committee with regards to your application. In terms of speakers, I don't believe we have any speakers. Nope, no speakers are registered for this item. Is there anyone in the audience who would like to speak either for or against this minor variance application? That's at 1871 Maryvale Road. Anyone? Not seeing anybody come forward. So members of the committee then,
Excuse me, Madam
yes,
Chair.
Ms. Willis.
I just wanted to suggest that we tie this approval to the life of the subject building so that any redevelopment of the site will not have the benefit of a variance like no landscaping around the parking lot.
All right, thank you, Ms. Willis. You beat me to it. I hadn't forgotten it, so but thanks for that, Mr. Bond. No issues with tying it to the life of the existing buildings.
Yeah, I don't foresee that being an issue in light of the fact that the building at the west end of the site was just recently constructed and that we're going to undertake a new construction pursuant to a site plan. I think the applicant would be content with that condition.
All right, excellent. In which case, I think I've already called for the public. Just remind me, I think I have already done that. Nobody, okay, thank you. Sometimes I get ahead of myself. So with that, then all those in favor of the application? All right, for the record, the application is unanimously granted by the panel. So thank you very, very much, Mr. Vaughn. I think we're done.
Thank you. Have a good evening.
All right, you too. Thanks so much. I'm going to go to application number 6 next, which is for 70 Greton Avenue. I'm looking for Clementi Porcari. Good evening.
Good evening. Can you hear me?
Yes, excellent. We can hear you. Need to read something to you with regards to the sign. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the subject property to which the application applies, that it was there for the prescribed number of days, and that it was also clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
Yes, that is true.
Can you say that you swear or you affirm?
I affirm that that is true.
Thank you very much. Okay, no presentation requested for this application by the panel members, so I'm going to go straight to questions. Mr. White.
Thank you, Madam Chair. I just have a couple of questions with respect to staff report, and I think some of the information is mentioned in the applicant's submission as well with respect to the surrounding area on Granton Avenue, essentially the character of the streetscape on Granton in this area. I noticed in the staff report that staff identifies that there are 25 properties surrounding on Granton, which have an approximate average lot width of 24 meters, which exceeds the minimum lot width requirement of 19.5 under the zoning bylaw. They also point out that there are 6 properties have lot widths below the minimum requirement, only 2 of which, 94 and 96 Granton, are in the range of the 15 meter, 15.2 meter reduction or lot width that's applied for in these applications. And then they range up to 19.2. These are the ones that are currently below the minimum requirement, ranging up to 19.2. I would like to ask staff if they can tell me when those reductions down to the range of the 15.2 meter provision actually were approved, the 94 and 96. And also how many are in the range of 18 to 19 meter minimum, which is somewhat below the current bylaw requirement, when those would have been approved, if there's a timeline for that, those variances. In addition, with respect to the lot area, there's also mention of 25 properties with frontage on Granton Avenue located within Pender and Cordova that have an approximate average lot area of 682.89, exceeding the minimum bylaw requirement of 600 meters. I think clearly from that statement with respect to the lot area and with respect to the lot width, the dominant character of this street, at least this street, exceeds the bylaw minimum requirements. Also, they mentioned with respect to lot area that the range in the lots that do not conform are down to 417.21, which I think is basically similar to what we're looking at here. Sorry, I guess we're looking at 441 meters to 573 square meters. The bylaw minimum requirement is 600. Again, it only identifies one that's in the range of the 417. When did that occur? When did that grant, when was that approved? And up to the range of the 573, when were those lots permitted by the bylaw? Or sorry, by approvals granted by the committee adjustment. I'm looking at a timeline on when these approvals of these significant, in my opinion, significantly substandard lot width and lot area requirements were granted as compared to the higher range of the variances that were granted on this street.
All right, thank you, Mr. White. Ms. Cully. I think what Mr. White is looking for is the question is, did you undertake that kind of analysis as you wrote your comments? So did you look at what those timelines would be?
Sorry, Madam Chair, I did not look at those timelines. I started looking at those timelines as Member White was asking the question there, just to get an idea. The lowest range there was the first I could actually get up in time as I was listening. And the 9496 was approved in 2013.
Okay.
Okay. Now, so, I mean, in terms of the dominant character on Granton Avenue, I think the report clearly indicates that dominant character is the large lots which exceed the bylaw requirements. Am I correct in that?
There are larger lots on the street, yes. But there are also ones that fall below the requirement. Yeah. That was just the intent of the paragraph, was to highlight that there is a character on the street that has lots by average, but there are ones that fall below that character as well.
But the dominant characteristic is for the larger frontages which exceed the bylaw requirements.
With respect to the lot widths, yes, there are larger lot widths along Granton, if that's what you're asking.
That, what I'm asking is the dominant character, and I think it's reasonable to assume, given the numbers that are shown in the report here, that the dominant characteristic is the larger frontage, larger lot area lots on Granton. In other words, they're going back to the they're the traditional existing lots in this plan, on this plan of subdivision, which is the dominant character. Thank you.
All right, thank you, Mr. White. Any other questions from the panel? Okay, so I do have a speaker registered for this item, Ms. Laura Cohen. But I also see Ms. Wilson is with us this evening. Do you want to come forward?
Hi, Madam Chair. I'm sorry, Laura's not feeling well this evening and neither is Jill, so I'm going to take it on for the three of us. So I might talk a little fast because I want to get through everything in the 5 minutes. So first of all, we'll talk about the 4 tests. The City View Community Association maintains that the requested variances to facilitate the development of these 2 detached dwellings on undersized lots do not meet the general intent and purpose of the zoning bylaw. These variances are not minor in our opinion. Also, we consider variances for a single build to be not minor. We consider 4 variances for a single build to not be minor. Planners should encourage builders to, just one sec.
Life gets in the way sometimes.
Okay, there he is. He's gone. Last word. Also above, okay, where were we? Also, we consider 4 variances for a single build to not be minor. Planners should encourage builders to build according to the existing bylaws where they can. Plans should be adjusted to eliminate additional variances. The trees, in City View, we are limited to using certain areas in our yards because of the ditches. So in the city's additional comments, the planner is strongly recommending that a new tree be planted in the right of way on each property. In City View, this area is preserved for our rural drainage ditches and cannot be used for tree planting. Yet the developer is asking for a variance to permit the garage to extend out into the front yards of the property, which only makes it more less space for a tree to be planted. Infrastructure. The City View has no storm sewers. New builds in City View have filled the ditches and provide no culverts under the extensive driveways. And drainage is drastically affected. In recent discussions with the City of Ottawa, we've been advised that ditches and culverts under driveways are a requirement of construction. Therefore, this requirement should be noted in the conditions of all infills here, and as-built review should be done. This has not been enforced in the past, and therefore City View now has rural drainage ditches that are no longer functioning properly. It is worthwhile to note that GOBA, the Greater Ottawa Builders, recently provided their comments on the draft official plan in respect to the infills. Infrastructure, the city's existing infrastructure will not be able to handle increased levels of intensification as indicated by the city's analysis. There are serious problems with respect to stormwater management and serious challenges with how it's going to be addressed as housing development intensifies. Then if we move to lot coverage, the City View Community Association would like to confirm that the porches are not part of the basement footprint and therefore not included in the lot coverage. I'm going to skip cash in lieu because we talk about that all the time in development fees. So read the city comments. The rear yard setback. The city claims the intent of the rear yard setback provision is to reduce potential privacy issues and loss of open space. Privacy for the property abutting the rear lot line is maintained despite the sought relief, as the approximate measurements on Geo Ottawa indicate the property has a rear yard setback of 10.2 meters. We beg to differ in this comment. The other property is abiding by the bylaw and expects that the privacy will be looked after if the new build abides by their setbacks. Just because they have more room on the other property doesn't mean that the other guys should be able to move up and encroach on them. The new build should adjust their plans accordingly. This could be done easily. The city planner also states, in addition, the site plan illustrates this properly with a separated that the property would be separated from 70 Granton by a cedar hedge. This is related to a side yard setback between the 2 new homes, so it's a moot point when we're talking about rear yard setbacks. The city also notes open space is also maintained as the proposed rear yard is composed primarily of sod. This doesn't make sense to us. As the plan note, a covered canopy on the rear of 70 Granton. We are unsure of the size of this addition and how it affects the rear yard. How can the backyard be comprised primarily of sod if there's a canopy existing out there? Garage setback, section 139(3) of the zoning bylaw details the front-facing garage provisions applicable to all properties within the Greenbelt. This is a brand new bylaw from the consolidation, which other builders have had to abide by. So why are we allowing variances to a brand new bylaw when these plans could be adjusted? Again, we question why we have bylaws at all. Infill numbers, and I think Mr. White has already talked about this. With respect to the city's comments, we note that there are discrepancies, and we recommend that if they intend to use comparison statistics, they should be accurate. The city claims that out of 25 surrounding properties with frontages on Granton Avenue, located between Pender and Cordova, 6 properties have lot widths below the minimum required. Also, the city notes that there are 8 properties with lot areas below the minimum required. From GeoMaps and lists of infills, we calculate that the 13 properties on this block, the only properties below the required sizes are 74 Granton, which is 50-foot lot under the hydro easement, and it's grandfathered. It had to be a 50-foot lot when it was built way back when. And 61 Granton is a 50-foot lot. This is 4% of the properties on this block. Out of the 16 properties on the next block between Bassano and Cordova, only 2, 94 and 95 Granton, have 50-foot frontages. In conclusion, we would like to mention that other cities require floor plans for applications. The number of bedrooms and bathrooms need to be accounted for in order to do comprehensive density studies to support the new draft OP and infrastructure concerns. Thank you very much for your time.
Thank you, Ms. Wilson. That was a very fulsome submission, and I'd like to thank you for taking the time to both prepare it and to bring it forward. So a lot of good things for us to consider. And as you know, we are aware of a number of those issues that are more neighborhood specific with regards to efforts by the city to intensify in that area. So thanks again. That was very, very helpful to the committee. Any questions to Ms. Wilson? Okay. Well, I think that's testament to your great, your well-prepared submission and presentation. So I'm going to just make a call out to see whether or not there's anyone else in the audience who would like to speak either for or against this minor variance application. Okay, I'm not seeing anybody else come forward. So with that, we're going to close the public portion. Committee members, is there any, so I'm opening it up to you. Would you like to discuss any of the aspects that we just heard about from Ms. Wilson? Yes, Ms. Markovich.
Yeah, maybe I could just ask a question of the city, because I know the infrastructure issue is one we hear about quite a bit. I'm just wondering if the city can provide any sort of response to the concerns raised about infrastructure, particularly in this street and neighborhood. Thank you.
All right, I believe Ms. Cully, you're on deck.
There we go, get myself on mute. Through you, Madam Chair. Thank you, Member Markovich. From my understanding, there has been communications with the city and the City View neighborhood with respect to infrastructure. In the past, there has been certain correspondence and questions that have been asked and have been responded to. I can't list them off verbatim at this moment, but there have been a number of things that have been discussed with regard to sewers, and engineers have provided responses to concerns with respect to the infrastructure. So I'm not sure specifically what you'd be looking for an answer to, but.
Yeah, I was just wondering if, I can't remember what they had sort of confirmed in terms of, just concerns about exacerbating issues around, say, the sewers and things that were raised here. I know in the past, we've gotten some specific direction from the city. I was just wondering if that could be re-summarized here today at all. I just thought it'd be helpful.
Sure, I understand that. I don't have anything necessarily prepared. It might be better to have something that is summarized. If the City View Community Association is looking for that sort of information, we can provide answers to specific questions. I'm just not entirely sure what the answer to the question would be in this format.
Gonna go to Mr. White.
Thank you, Madam Chair. I hesitate to go back in history, but I can advise the committee that in the past, and I'm talking about 20 years ago now, the former city of Nepean identified localized infrastructure issues in this community when it was in the process of considering minor variance applications and additional lot creations in the area. And there were limitations that were placed on recommendations with respect to minor variances and lot sizes on the severance applications and new building lot creations in the neighborhood, based on some of those concerns and based on, frankly, the bylaw minimum requirements that existed since 1962 and which still exist. In response to those concerns with respect to infrastructure problems, the former city adopted an infill site plan approval process in this community, which included all of the considerations of servicing, adequacy, grade control and drainage, building siting, et cetera, and the registration of site plan agreements on properties before building permits were issued and in support of any applications for minor variances. So there were concerns in the past. I'm not aware of work that's been done subsequent to that by the new city of Ottawa to comprehensively analyze the servicing situation and the engineering infrastructure situation in the neighborhood. And that's why I've always expressed some concern about the minor variances and lot creations that we're being asked to grant at this committee. In the absence of a comprehensive engineering and infrastructure review, and most significantly, in the absence of any comprehensive review of the zoning bylaw requirements since 1962. And my position, as you're aware, has consistently been the general purpose and intent of this bylaw has not been changed since 1962. And the minor variances that we are being asked to grant consistently almost every meeting are not consistent with the general purpose and intent of that zoning bylaw in the absence of that comprehensive review. On that basis, as you know, I'm going to not support this application. And in my view, it's the minor variances are not minor, and they're not consistent with the general purpose and intent of the bylaw. Miss Wilson has very, very coherently expressed some of the concerns that I share with the community for these recent infill applications that come before you. And the evidence that I heard from staff today was that it's since 2013 that these kind of variances have been granted. And I'm not aware of prior to that minor variances to the extent that we're being asked to consider these days were ever recommended for approval nor approved by the Committee of Adjustment for the City of Ottawa and certainly for its predecessor, the former City of Nepean. Again, I'm not going to be supporting this application. Thank you.
Thank you, Mr. White. Ms. Culling, I see your hands up.
Through you, Madam Chair, I was looking for some information in order to provide a more comprehensive response to Member Markovich's question. There was some information that I have available to me that I will read here because it's a little bit word heavy, but essentially this area of the city was studied after a 2004 flooding event where widespread flooding occurred. The study essentially identified that the sanitary system was the problem, so improvements were made to the sanitary trunk. And these improvements were successful as it demonstrated during a similar event in the community in October 2017. There was little to no reports of flooding. And then apparently there was a public meeting approximately 10 years ago from the date of the email, which would have been 2008, I would estimate. And apparently staff presented the idea of providing storm sewers in the area via local improvement process, but that idea was not something that the residents were in favor of at that time. And then on top of that, when we're looking at infill and redevelopment applications, they're looked at on an individual basis to ensure that they don't impact the existing drainage system. When redevelopment is done, it actually has a positive impact on the sanitary system as the existing foundation drain is removed and the new connection is directed to the ditch via a sub pump. And the reason for this is because it's not allowed to drain into the sanitary system. So this provides a net benefit to the sanitary system.
Okay, thank you so much for pulling up that material. I do appreciate that. Was very helpful. Thank you.
Thank you, Ms. Cully. That is, in fact, very helpful. I believe we've had that information provided to us by planning staff, and I think most of us, if not all of us, have had a chance to review it and digest it. Mr. White, I just want to make the comment that we have flagged the issue about its intensification literally changing the intent of the zoning in the area just through approvals. And I believe that that is an issue, again, not necessarily specific to City View, that we are looking to get increased clarification from city staff. So the issue is not over with regards to what the expectation is, and that's going to be in a future meeting of the committee of the whole. So, okay, with that, then, any other questions by the committee on this? All right, I'm going to go to a vote then. All those in favor of the minor variances. Okay, Mr. White, your hand is up, so I'm going to assume that you're dissenting, even though your hand is up. I just want to be clear. That's what you're doing.
Sorry, Madam Chair, that's my electronic hand. That's not my voting hand.
Yeah, okay, fair enough. Fair enough. I just didn't want to make sure, I just didn't want to make the mistake if in fact that was what you were doing.
Thank you.
All right, so in this case, I am also refusing the application. So the application will fail as a result of that because there's only two of us this evening. My reasons are not because of infrastructure or any of that. My reasons are very simply that I don't believe that I was given compelling evidence to indicate that in fact, the intent of the zoning bylaw is being supported. And it goes back to Mr. White's questions about what is dominant on the road, on that street in particular. Then, I mean, never mind the neighborhood, we know what's happening in the neighborhood, but on that street itself, not convinced that in fact it is in character with the rest of the street. So don't believe it's in keeping with the intent of the zoning bylaw. So with that, Mr. Bakary, your application does fail. So you'll have a choice to then appeal the decision. The landowner or your client will have the choice to appeal.
Okay.
All right. Thank you very much, Mr. Bakary.
Thank you.
All right, with that, then we're going to the last application for the evening, which is 235 Mariposa. I believe I'm looking for Ms. Belfi.
Hi, good evening.
Good evening.
Yeah, good evening.
Great. So I believe that I do need to read something to you. I don't believe we have the stat deck. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies for the prescribed number of days before the hearing and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm that to be true. Yeah.
Okay, thank you. I don't believe the committee wants a presentation this evening on the application. So I think we're going to just throw it out to questions by the committee members. Anybody have questions for Ms. Belfi about the proposals? Okay, I'm not seeing any questions. So we do have a number, there were a number of submissions in opposition. Ms. Belfi, I assume you've seen those? You've seen
Yes,
those
I have.
letters?
Yes, I have.
All right. We do have speakers for this evening from 250 Manor Avenue, and Mr. Michael and Sheila Kellen. So I see Mr. Kellen, you're with us.
Yes, thank you, Madam Chair. Madam Chair, members of the committee. My wife Sheila and I we live at a neighboring property, 250 Manor Avenue, and we actually have lived here for over 35 years. So we know the neighborhood very well. As a matter of fact, I was before amalgamation, as you know, Rockcliffe was a separate municipality, and I was the chairman of our Committee of Adjustment for 12 years and served as a panelist on the committee before that. So our objection is that this house at 235 Mariposa, they're seeking two variances. The first is to allow a variance of the side yard setback. It's supposed to be 15 feet, but it's closer to the property than 15 feet. And they want to extend the house so that wall along that side yard will then be extended even higher for the neighbor. That's not very pleasant. And for all the residents, it takes away from the character of Rockcliffe Park. The Rockcliffe Park, as you know, is covered by a heritage plan. The heritage plan was enacted by the City of Ottawa in 2016 under the Ontario Heritage Act. And I don't know if your committee considers such things, but the Ontario Heritage Act says that in the event of a conflict between the bylaw and the heritage plan prevails. Well, the main purpose of the heritage plan in Rockcliffe Park is to conserve the green spaces. The heritage plan provides that there will be generous open side yard setbacks. So to further increase the height of this building so that it's closer to the property line than the required 4.5 meters or 15 feet, that variance should be denied. This house is the second application for a variance is to allow the house to be built higher than it is already and higher than the bylaw permits. But under the heritage plan, it also provides that an addition to an existing, this is a grade 2 house, the addition must be in compliance with the character of the streetscape in terms of height, mass, setbacks in that regard. And this house is already the largest house on that section of Mariposa Avenue. And to basically add a third floor to it makes the house too massive, too tall, and out of character with the streetscape. So for that reason, my wife and I oppose the changing of the character of this house, which is already large. And so we think that both variances should be dismissed. We know that the house has always been too close to the property line on the western property line, but that doesn't justify the applicant being allowed to increase the height by another 10 feet too close to the property line. And as far as the height, we know the applicant says that this is a mistake. The bylaw was inadvertently amended to reduce the maximum height that's allowed. And well, that may or may not be the case. I know we have had other situations in Rockcliffe, for example, with respect to accessory buildings, the setback for Rockcliffe has always been 5 feet. And there was a bylaw passed by the city in 2006 that made the setbacks for accessory buildings 2 feet all across the city. And I worked hard to have the city amend that to reinstate the 5 foot side yard setback for accessory buildings. But in this case, that should not happen because this house is already too massive. The purpose of the heritage plan was, as the Ottawa Citizen reported when it was passed, City Council passes heritage plan for Rockcliffe Park to prevent the further construction of monster houses. And that's what's happening in our neighborhood. These houses are being built out of scale. They're too massive. And I'm not dealing with something that is not the subject of a variance, but just by the way, one of our neighbors has dealt with this. What they're adding on the back is bigger than what they've got already in the front part of the house. So the house is just going to be huge. And the other neighbor questions, why is there so many bedrooms? This is a single family residence area. And when you add another floor, you're bound to have more and more bedrooms. They've already got 6 bedrooms on the second floor and 2 bedrooms in the current size of the house on the third floor. I mean, this can't be a boarding house. This is supposed to be a single family residence, which in this case is for the High Commissioner of Uganda and her family. So those are our submissions. The house should not, the variance should not be allowed to increase the height because the house is already the tallest on the street, and additions are not allowed that would make the house out of character with the street, which this would. And second, that it's already too close to the property line on the western property line, and they should not be allowed to add another 10 feet of construction along that wall that's only 10 feet from the property line instead of 15. And by the way, in Rockcliffe, most setbacks on the side are 20 feet. That's what makes Rockcliffe why it has the green ambiance it has. The 15-foot setbacks are absolute minimum, and it should never be varied.
All right,
Anyway,
thank you, Mr. Killen.
All right, and let me ask you a question, if I may, Madam Chair. Does your committee ever take into account the effect of the heritage plan?
Absolutely. We always ask where we are in that process. And in fact, that is definitely, we're going to explore that in just a minute. I was just waiting for you to wrap up, and then we were going to get some answers to your questions.
All right, thank you very much, Madam Chair.
All right, so Ms. Belfi, I saw you taking notes as I was while Mr. Killen was speaking. I think there's a number of things that he's raised for consideration. The heritage designation, the process being number one, how that works. Confirm the use of the house, essentially. Not that we can do much about that from a planning standpoint, but just to give Mr. Killen some comfort. And then address the two. You didn't get a chance to do your presentation, so in this case, you'll get a chance to explain those 2 minor variances. And my only question too, then, though, just off the top, though, is when was that house built? Do we know what year the house was built in?
Yes, Madam Chair. From my understanding, it's about 65 years old. So I think probably in the mid 1950s was when it was built.
All right, so nothing recent. I just wanted to make sure it's got legal non-conforming rights, all of that. Okay, that was it. So go ahead, Ms. Belfi, with regards to responding to some of Mr. Killen's issues.
Yeah, thank you. So the first thing I wanted to confirm was that the building is going to be the home of the Ugandan High Commissioner and her family and staff and her staff as well. So it's not meant to be a boarding house. It's not going to be anything else. It's meant to be used by the Ugandan High Commissioner. The property, as we said, it's in the Heritage Conservation District, and it has gone through a full process of heritage review. It has received a heritage permit. Right from the get-go, right from the pre-consultation, the Heritage Committee of the Rockcliffe Park Residents Association was involved. They attended the pre-consultation. And so the plans, there was quite a bit of consultation, and the plans were revised a number of times to address comments, not only from the City Heritage Department, but also from other people as well. It went through the process, and it went through to Heritage Committee and then to Council, and received the heritage permit in September of 2020. So not this September, a year ago, September of 2020. In the report, they certainly, obviously, one of the things that they have to address is the height and massing of the building. And what's happening is that the height it kind of goes to that minor variance, the technical variance we'll call. The height in Rockcliffe Park has always been 11 meters, and for many, many years. I don't know when it actually started, but for many, many years. And so through a technical error at the City of Ottawa, the height got reduced to 8.5 meters. So in our initial submission, we weren't asking for a minor variance for height. It's because it was under, at a building height of 10.2 meters, it was under the zoning requirement. The plans that are before the Committee of Adjustment are the plans that we received approval from the Heritage Committee. I wanted to make sure that was clear. There has been no increase in height since the Heritage permit. They're the same plans, not only for the building alterations, but also for the landscape plan. The Heritage permit covered both of those items. The roof line is being increased. That east wall where the side yard is, that we were asking for the 3.9 meter side yard setback, is going to be increased by about 1 meter in height on that elevation. And the purpose of that is there is an existing third floor in this house that has a couple of bedrooms on that floor. And because they're doing this renovation, obviously it has to meet building code. And those bedroom ceiling heights did not meet building code ceiling heights. And so they're having to obviously make the ceilings tall enough. The pitch of the roof is going to be slightly steeper than what is there currently. And so the Heritage planner in their report, it was their opinion that this increase in height would not be as apparent as you might think, because the pitch will be steeper, and there's going to be dormers all along the front in that roof line, and so that's going to break that up as well. And so it was their opinion that this increase in height was appropriate. The home is going to be built on the same foundation, so there's in terms of massing, they were saying that they were comfortable with that. That is the same setbacks and footprint of what is there with the foundation. And there is the slight increase on the west side, but it meets zoning requirements. There is an addition at the rear of this property, but it's being brought in further. One side is going to be over 7 meters setback on the west side, and on the east side, it will be, I think, 5.1 meters from the side property line. So the rear addition will not be evident from the street at all. So, the main variance was to allow the increase. Was the reason we had to get the variance for the existing side yard is because any new construction has to meet the zoning bylaw. In this case, the eastern sidewall is being extended in height by 1 meter, and so that 1 meter height on the east sidewall technically is supposed to be 4.5 meters, but it doesn't make sense to have that 1 meter set back. They would like to have it straight up and down over the existing wall. And so that's why we're asking for the 3.9 meter side yard.
All right, thank you, Ms. Belfi, for that explanation. Any questions from the panel members? Yes, Ms. Willis.
Yes, just a question from Ms. Belfi. Did the neighbors to the east on the side with the deficient side yard variance comment on this application?
Do you mean at the Heritage permit stage or at this committee?
Call it just whether they had any input into this, or the most directly affected by this reduction which exists today, and just wondering whether or not they had provided input or objected to it in any way.
During the Heritage approval process, all the neighbors within a certain distance, I believe it was 30 meters, were circulated, and according to the Heritage report, that had done, and the Heritage Committee of the Rockcliffe Park Association was involved, and the report also indicates, I think, Heritage Ottawa was notified. So I don't know at that stage whether the immediate neighbors provided direct comments to the Heritage Committee.
Okay, but they did not provide any input into this process before the Committee of Adjustment?
Not that I'm aware of.
If I may,
No, Mr. Kellen, no. your opportunity at this point we've heard from you. It's now the panel members' chance to get clarification from Ms. Belfi in her response to the items that you have raised. So that's what I'm after right now. So any
Yeah.
further questions at this point from the panel members? All right. I'm going to go to the next speaker, Mr. Kellen. That's the next place I'm going. So, and I see, even though I don't have anyone on my list at this point, Mr. Kellen, you and your wife are the only ones who registered. I see that we have a gentleman who's going, I apologize, what I'm seeing is Nancy. So I am going to need to start your full name and your address, please.
My name is John Davis. My wife is Nancy DeRigo. We live at 216 Manor. We are immediately on the west side of the property of the 235 Manor Posa property.
All right.
And we have, sorry, Madam Chair, go ahead.
Yeah, no, you have the floor, so go ahead,
Thank
Mr.
you.
Davis.
So
I see you've written a submission in. Okay, so thank you.
we have written several submissions, and we'd just like to clarify two things. One is that we have at no point been contacted by the developer for the purposes of getting input from the for the development of the property, and that our submission in September of last year highlighted concerns that we had with the development. The second part we'd like to make, just to comments recently made by Ms. Belfi, is that the footprint of the building, the foundations are not sufficient, simply because the foundation of the building is twice the size in depth of the existing building. Therefore, the foundations will not be sufficient to support the mass of the building as proposed. So one of the concern that we have and submitted to the committee is that our submission is that the requested variance is not minor, and the proposed structure would require to the zoning changes to the designated property based on the following. The property is R1B, it's a residential property. The property is classified as currently an oversized building because of the number of bedrooms. The property as is has been used as a diplomatic residence, but recently has been used to house non-diplomatic staff. And our concern with the construction as is that this building, the way that the building has been configured, having 6 bedrooms with ensuite bathrooms on the second floor, and recognizing, as put in the original submission by the developer, that the bedrooms on the third floor will be occupied by staff in the house. We are now looking at a development that has 6 bedrooms, not for staff for the house who are housed on the third floor, but look more like a rooming house in the sense that these are bedrooms that are not for immediate family of the diplomatic staff, but are more in line with having accommodation for working staff within the overall diplomatic mission of Uganda. And we believe that that is not an appropriate use for the building, and therefore would require a zoning change. We went through the rest of the building where there are 11, basically the size of the building and the use of with the bedrooms is not consistent with the use as a single family dwelling for a diplomatic residence. That's basically the essence of it. The second part is, from our perspective, the size and mass of this building is almost double the width of the current building, which does impact our property. We have a very mature tree line on the side of the property. The trees are ironwood trees. We have real concerns that the tree line will be damaged simply because you can't get massive equipment in to do foundation work down the size of the building without damaging the trees. So there are logistics issues associated with it. A comment made by Ms. Belfi in a letter to us, our first communication with her last week, was that there is no difference in the size of the setback, whereas going back to the site plan, as we noted in the submission that we made to the committee, the setback of the new building is 4 feet closer to our property line than the current building, unless there's been a change to the setback on the site plan. That's how I read the site plan. It's 4 feet closer. It's 1.2, 1.3 meters, which is approximately 4 feet. So we are asking that the committee consider these things, these zoning, the size of the building, the use of the building relative to its position as a single family dwelling. The reference to having staff in the building is accommodated by within the current plan with 2 staff on the 3rd floor, as in the developer's own submission. So our concern is that we'd end up with continued use of the property, not as a single family dwelling for the High Commissioner, but as a facility in which other staff or other entities have residence, which would increase the needs for parking, increase the traffic, increase the noise level, and basically are not in compliance with the zoning as R1B. And that's the submission. Thank you.
All right, thank you, Mr. Davis. I'm going to call on staff at this point just to get at that particular issue. So, and before we go there, Ms. Belfry, just to confirm, there will be staff actually residing in the house, is that correct?
That's correct.
Okay, so Ms. Ramirez, does that change things from a permitted use standpoint?
Well, the dwelling, through you, Madam Chair, this is a detached dwelling. The zoning bylaw doesn't make reference to single family. Household is not something that we get into regulating. It doesn't have to all be related. It needs to function as a household.
All right, so but I think what we're here, okay, so the staff is specifically, it's domestic, like it's household staff, not administrative staff in any way. Is that correct, Ms. Belfry?
I'm not sure. I haven't asked who's going. They told me that staff would be there. Potentially it could, you know, as the speaker has suggested, it could be working staff and their families that perhaps, but that's still considered, in my opinion, and under the zoning bylaw, a household, that they may not be related by blood, but they're still working together. And I believe there are also staff that will be like the chauffeur and the people that look after the home as well.
All right,
And also obviously the High Commissioner and her family as well.
all right. Ms. Ramirez, you concur? No issues if we actually have a household where we've got staff that's not actually there to just run the household, but rather be involved in the business of the commission?
Sorry, Madam Chair, I missed the first part of that question.
So there's a difference in my mind between a single family home that has staff that help with the household operation. That's a different story. You're allowed that. We're allowed nannies in our homes. We're allowed those kinds of things. But if we've got staff that is actually there to operate the business of the commission in the house, does that change anything? I'm going to ask whoever is Joy Action to please put, thank you. So Ms. Ramirez, does that make a difference? Or I'm just trying to wrap my head around this. Maybe not, like maybe if they're, you know, I guess what I'm thinking, and somebody can correct me here, but if those members are not necessarily household staff, but still are part of the Ugandan Commission, but don't work there necessarily, they don't actually do business of the commission while they're there because they're just residing with the family, then that's a different story. So Ms. Belfry, do you know that answer off the top?
No, I don't. In my opinion, this was an application for a minor variance for a side yard setback. It wasn't a question of the use of the property. And it seems to me that perhaps might be for some other situation. But I told you what they have told them at the Heritage Committee. I've read the Heritage report and I've talked to the architect, and that so that's that basically I was told that it was for the High Commissioner, her family, and her staff. So I can't just distinguish with what staff means.
All right.
Am I allowed to say anything?
If we're just, I will come to you. Yes, I will come to you. I haven't not noticed that you're there. I just wanted to get some answers to the previous speaker's questions.
That question, if I'm allowed,
All right,
because
can I get you? Okay, all right. Come forward, if you will. Please put your video on and unmute, and I will get you your name for the record and your municipal address. Are you able to?
I'm looking into how I can put my video. Oh my goodness. I am failing. I am failing to get the exact place where the video is, because I'm using, okay. Oh.
To the coordinators, is it possible for us to have control to turn that on, turn on the video? No? All right, so is it Achen? Is Achen?
Achen, yes, Achen.
Okay, so can I also have your address for the record, please?
Yes, I am Joy Ruth Achen, Ugandan High Commissioner, and I'm currently residing on 149 Buena Vista Road, Rockcliffe. And the office address is on 350 Spark Street.
All right, thank you. I just need that for the record. So that's so you are the Ugandan High Commissioner. Did I get that correct?
Yes, you got it correct. I just wanted a small clarification on the numbers of rooms and then the staff. The rooms could my neighbors and the concerned parties could look at it as being many rooms than necessary, but I'm a mother of 6 children, and I have 2 domestic workers that the Global Affairs directed that I should give them accommodation, and I have young children in the house, so they cannot stay outside the house. So those rooms will accommodate the 2 domestic workers and will accommodate my 6 children and myself.
Thank you very much for that clarification. That's exactly the information that we needed in order to be able to, I guess, determine that in fact this isn't a permitted use issue. So you are functioning exactly as intended by the bylaw. So, okay, so that's fine. Mr. White, I see you have a question.
Yes, Madam Chair, I'd just like to point out that we're not, the Committee of Justice, as a Committee of Justice, we're not being asked to rule or judge on the use of the property. We're only being asked to deal with applications for minor variance with respect to side yard and building height. So the issue of land use, the use within the building, that's a matter for zoning bylaw enforcement at the city level. It's not something that we as a Committee of Adjustment are being asked to deal with, or nor do we have the authority to deal with.
I'm going to have to disagree with you, Mr. Wright. I believe that if in fact there is a permitted use issue here, then it would mean that we would need to adjourn the application and look at whether or not an additional variance would be required, or so. So in my mind, what we've been able to do is actually conclude that in fact it is going to operate as a single family home for that purpose, in keeping with what they, so that was essentially what was raised by Mr. Davis as his concern. And I believed it to be a valid concern worthy of exploring. So with that, we do have our answer. So that's the good news about that. Anything else?
Madam Chair, Madam Chair, we'd like to, knowing that there are 6 children and that the building is going to be used for the family, we have no objection to that.
Thank you very much, Mr. Davis. Appreciate that. Okay, any other speakers that want to speak either in favor or in opposition to this application? All right, I'm not seeing anybody at this point, so I think committee members, we can make a decision. All those in favor of the minor variance application. All right, for the record, the application is unanimously granted. So thank you for your submissions, everyone this evening. Thank you, Mr. Etchen or Ms. Etchen, for your information as well this evening. We appreciate you taking the time to join us and to provide that clarification. With that, good luck with the project. And
Thank
that
you.
brings us, thank you. So that brings us to the end of our agenda for the evening. I need a motion by the committee members for adjournment. So motion to adjourn by Ms. Willis, seconded by Ms. Markovich. So with that, I'd like to thank our planners and our committee staff again, and Ms. Young for also participating and being available and providing information to us this evening. We truly appreciate all of the support that you provide us during these meetings. So thank you, and we'll see everybody in about 2 weeks.
Thank you. Good night.